Good morning. This is the Kelso Report for Monday, June 25th, and I'm your host, Clark Kelso. Well, of course, the big news today probably is going to be the Supreme Court's release of its health care decision, as well as its decision on the Arizona immigration law. But let's go ahead and review what we got from the Ninth Circuit and the California Court of Appeal last Friday. First, for the Ninth Circuit. The scope of a habeas remedy for ineffective assistance of counsel was before the Ninth Circuit in Johnson v. Uribe. The district court found that trial counsel had been ineffective at the plea bargaining stage of proceedings, resulting, among other things, in the district court imposing an 11-year sentence for 4 theft-related counts for defrauding an auto dealership and stealing a vehicle. The district court's remedy was to grant the writ subject to imposition of a new sentence within the lawful range for the crimes for which the defendant pled guilty. The Ninth Circuit reversed, holding that because the ineffective assistance affected the entire plea negotiation stage of the proceedings, the appropriate remedy was to vacate the conviction and return the state proceedings to the pre-plea stage. Given the ineffective assistance, the defendant was entitled to a completely new set of negotiations, which would give the defendant the choice, among other things, of refusing to plead guilty altogether. Next, we have an interesting right to a public trial case. The defendant in United States v. Rivera was convicted of possessing with intent to distribute 215 grams of methamphetamine. Defense counsel indicated the defendant wanted his family members, including his wife and young son, present at the sentencing hearings. The district court, expressing displeasure at what it perceived as the manipulative use of the defendant's young son as a sentencing prop, continued the sentencing hearing, and then ordered defense counsel to show up 3 days later with just the people involved. As though the family, I guess, is not involved. The Ninth Circuit reversed, holding that the defendant's Sixth Amendment right to a public trial was violated by the district court's exclusion of his family members from the sentencing proceedings. Ninth Circuit remanded for resentencing. We'll see if the district court here is tough enough to deal with the fact that the defendant has a family and a young son. Next, criminal sentencing. The defendant in United States v. Suarez was sentenced to 20 years imprisonment for conspiracy to distribute and to possess with intent to distribute methamphetamine, based on a statutory minimum for defendants with a prior drug conviction. The defendant argued that his 2003 guilty plea to a felony drug possession in California had not become final, as required by federal law, because he had entered and completed a drug diversion program instead of actually being convicted and sentenced to prison. Examining the legislative history of the applicable federal sentencing statutes, the Ninth Circuit concluded that in order to qualify as a final prior conviction, a guilty plea must either 1. Ripen into a final judgment, or 2. Result in a legally cognizable sentence. Since the defendant's state plea and completion of the drug rehabilitation program resulted in neither a formal entry of judgment by the state court, nor a sentence of imprisonment or probation, the Ninth Circuit held the district court erred in applying the 20-year mandatory minimum sentence to the defendant. Next, we have a state law Government Tort Claims Act. In Mixon v. State of California, the First District affirmed summary judgment in favor of the state and Pacific Gas and Electric Company in a tort action arising out of an accident at an intersection on a state road, where a motorist struck and injured a boy walking with his family in a marked crosswalk at night. The plaintiffs alleged that the state and PG&E maintained the intersection in a dangerous condition, which would make them liable for injuries under Section 835 of the Government Code. The plaintiffs faulted the lighting configuration, lack of traffic control signals and signs, placement of signs, the type of crosswalk markings, and the grade of the intersection. Now, although the question of whether there is a dangerous condition on property is usually a fact question for a jury, the First District affirmed summary judgment for the defendants in this case because the basic premise for all of the plaintiffs' claims was that the intersection was inadequately lit. And there are a long line of California cases holding that there can be no public liability for failure to light streets or intersections. When that element was taken away from the plaintiff's allegations, there was nothing left to distinguish this particular intersection as unreasonably dangerous. Finally, we close with an attorney's fees issue. In Pierce v. Western Insurance Company, the 5th District held that a surety that issues a bond to a retail vehicle dealer is liable to the same extent as its principal, and that if the principal would have been liable for attorney fees based on the conduct secured by the bond, the surety becomes liable for such fees under general surety law. The issue arose because Section 11710 of the Vehicle Code, which requires the bond, does not expressly authorize recovery of attorney's fees against the surety. But since the statute also does not expressly preclude an attorney's fee award against the surety, the 5th District held that the dealer's liability for attorney's fees under the Consumer Legal Remedies Act was sufficient to authorize an attorney's fees recovery against the surety pursuant to general rules of suretyship. And that's it for today's Kelso Report. Have a great day in the law. We'll see you tomorrow.